All right, so we're going to create a feedback loop on the phone. So I'm going to hang up with you. Okay, bye. Okay, let's see if this all. Okay. We are good. We are live, so everybody can hear us. I can mute us out.
We should have more light.
I didn't get shown the controls on the way. Oh, yeah. Great.
Oh, yeah. 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 All right, it is 6:15 on my watch. We have a quorum with all three directors present. So I call this meeting to order. Our first order of business. just for clarification, so people understand. You cannot approve minutes at special meetings. So that's why we have three meeting minutes to approve. So the first minutes are the August 1st BOD meeting. Are there any corrections?
Well, I think the last time we brought this up, you had said that you weren't allowing any corrections or addendums to the meeting minutes.
You asked for corrections. If there are corrections that everyone agrees with, the minutes are corrected. If anyone objects to a correction, then that becomes an amendment, which must be voted on.
So and I'll just make this as a general comment. When we're voting, I think the meeting minutes should have the exact language, both of the motion and any other things that are amendments, even if they're not approved. I think we should be documenting what is the motion for both approved and things that are voted down. I think those should be in the meeting minutes.
I hear what you're saying. Are there any corrections to the August 1st minutes?
So can we, I don't have a copy in front of me, so.
That's one.
Is that one? This is August 1st, good. So, under item. Under old business, Gmail account. You've moved that the secretary be the owner administrator of the email account. Is that a new policy?
That is not a correction.
Okay,
So are there any corrections to the minutes?
well, if it doesn't say that it's a policy in these minutes, can you clarify, have we changed the policy going forward? Is the secretary always the administrator?
What does
Or
the
is it-
motion say, Andy?
Move that the secretary be the owner administrator of the email account for this board at this time.
I believe that answers your question. So are there any corrections to this, to the minutes?
Can I submit any later on if I come up with any?
No, not once they're approved.
Okay,
All right, hearing none, these minutes are approved. August 15th, special meeting. Are there any corrections to the minutes?
I think it's that one.
and on this is the one where we don't seem to be including the actual, so you have the first of the proposed amendments, the others are not listed here. There were 7.
That is correct because they were not brought to the floor.
And they were not brought to the floor because they were,
Because it says in there, they were ruled out of order.
ruled out of order because you perceive them as policy changes.
As HOA policy changes. As opposed to administrative
Okay.
actions.
Could those items be tabled to a meeting where policies are being considered?
Give me a moment, I'm thinking. If there are policies that anyone wishes to bring to for the HOA, there are ways to do that. So anyone can bring forward policies to come to be addressed at some future meeting.
Okay, so those were submitted in writing. That was on August 15th. Could that be put on the agenda for a future, whatever the next meeting is?
So no, I'm not gonna, let me back up. I rescind that answer. I'm not gonna answer because that is not a correction to the minutes. Are there any corrections to the minutes? Hearing none, the minutes are approved. The last one is the September 9th special meeting. Are there any corrections to the minutes? Hearing none, the minutes are approved. All right. Next item on our agenda is report by Clay Jones on his efforts to find someone willing to serve as the ACC chair. Is that what we
Right.
call him?
Yeah.
Chair?
Chairman. I'm happy to report Bob Benninger stepped up and will be chairman of the ACC. So he will be sending out the various proposals for changes to a home. We have two that he'll send out. So we have now Sarah did she resign from so then are you on the committee? Okay, so now four of us, five will review the two that have been submitted. All of the various things that happened in the interim, of course, are approved because 30 days without a response and it automatically is approved. For landscape,
One moment, please.
Okay.
Sorry to interrupt. Are there any objections to Bob, what's his last name?
manager,
Benninger, being chair of the lands or ACC? Okay, lucky devil. All right, the landscape committee now.
okay, for the landscape committee, I've been sort of functioning as a single member without actually being on the committee by making sure that we stay within our water limits, turning the valves not to water after a rain, and pulling up a few weeds, but the front does need some attention. But I would, going into the winter, it's not so necessary to have it so constituted, but if anybody would like to be on the landscape committee, please let me know. So there's really been no progress.
No problem. I did find where the landscape committee was reconstituted in March of this past year, so. All right.
I have two questions.
Yeah.
So can anything be done about the scheduling on the water? It appears that we're watering 3 days a week, but 2 of the days are back to back. Is that intentional or is that just how it's working?
So we have Saturday night, Tuesday, and Thursday. I think that's the way the main system is watered.
Okay. It's showing up on so one of the days is showing up back to back on the billing. So it's showing 2 days in a row when you go to City Fort Collins. Yeah.
Gloria?
If you're looking at that, it goes over midnight.
That's what's causing the one
Yes,
looking at back to back.
It's that we have different zones that.
It takes that long.
Yes.
Got it. Second question is about the backlot mowing. We've discussed that a little bit. Is there Are we not considering a second mow?
No, we actually, I should have mentioned that. It took a while to get a hold of him. He does not return phone calls. But we now have either this weekend or the next,
Okay.
he will come out.
Is that, at this time though, do we need to do the edging or,
The edging was also included,
okay, so we are gonna do it second time.
yes.
Great.
All right, any further comments? Any questions from? Yeah. That brings us now to our new business, and that is the business of the policies. Now, I just want to help people understand that the wording in these policies, the board doesn't have any leeway. The wording, it has some leeway, but basically it comes out of the act that is referenced in the policy. So for example, when we get to the fourth policy, we received in the email an objection to posting notice on the front door. That comes straight out of the policy. We don't have a choice. Okay. So I just want to make clear that these policies are coming out of the acts that they reference. So the first policy is the proxy policy.
I move to approve.
All right. Hold on a second. So, we will first take homeowner comments on the proxy policy, if there are any. Yes.
I don't think any one person should have, say, 5 or more proxies at one time. Just a suggestion. I think one person can override the whole system if they have too many proxies.
May I respond to that comment?
Yes, go ahead.
So SB 059 is the bill that began this process for this change. The original bill actually sought to limit the number of proxies to 5% of the total number of votes. That got stripped from the bill. And if you participated in the hearings there, it was astounding, but literally the sponsor of the bill said out loud that he did this for a friend of his. And so we know that there was not good stakeholding in the process for that bill. And there were several people who came to testify for that bill. Piney Creek is an HOA with over 1,800 units south of Denver. And there are members there that are holding 500 proxies out of 1,800. And they regularly, they get 200 or 300 people to show up at a meeting and they can never overcome the proxies. It's a hot topic in a lot of HOAs. There's 12,000 HOAs in Colorado. It is likely to be revised again. Now, that said, I do have to say, the statutes don't say that we cannot have such a limit. We're not bound to only do what this bill did. In fact, all that this bill did essentially was to say that you can't have proxies over 11 months. So there were some people that were holding proxies that were literally years or decades old. They weren't dated. Our bylaws, as they exist right now in Article 5, voting section 3C, we already terminate proxies at 11 months. So we were already doing what this bill sought to do. The only thing that this bill does that our documents were not doing was to make sure that the proxy has a date on it, because you have to time it. We don't actually have a requirement in our current documents that say the proxy has to be dated. That's the only real change here.
So. Thank you, Andy. Any other comments from homeowners? All right,
So that said, I would be willing to consider an amendment to limit the number held by any one party. We can do that as part of our policy, even though the state law does not require it. We could consider that.
So is there a motion to amend?
I would make an motion to amend that no individual holds more than 5%. Which in our case, I think would work out to 3 or 4 proxies. We're gonna have 4. So no individual holds more than 4 proxies all on their own.
so given that there has been a proposed amendment, I'm going to go back to the homeowners. Are there comments on this?
Yeah, I think it's great. The loss is a very small amount. And I think it might be inhibiting homeowners who wish to get their proxy to someone who they have faith and confidence in to vote along the lines of their interest by requiring an artificial limit on the number of proxies they control, and thereby inhibiting their right to vote. Because they might not find someone who's willing to go out and select proxies, and if they're not there to vote, then they don't vote, period. So, no, I would be opposed to that. I think at the very least, the number, percentage is far too low. And you want some sort of participatory, democratic action in the HOA. And if you let people vote, and that's what you're doing, if you can't go out and select proxies, I think it's a mistake. And it has not been a problem in this community as far as I know. If people want to go out and beat the bushes and get proxies, and people don't want to give them to them, that's the American way. So,
Thank you. Yes.
Wouldn't that like go the other way too, since we have such a small homeowners association? Somebody could have like 20 proxies and maybe only 45, 50 people show up at the annual meeting, and they would have a very high stakeholdership in the way the vote goes.
but.
You know, it can go that way too.
Those people are trusting.
Yes,
their
they are.
vote to someone. I think they have the right to do that versus not voting at all, because that's, they just don't want to sit, some people just don't want to do it.
We've got 15 people now. There's eight attending and 7 on Zoom, and somebody shows up. I'm not saying that it could happen.
This is not an HOA meeting.
No, it could happen at an HOA meeting where they're voting. Somebody's got 10 proxies, they're going, plus their own vote.
Well,
I don't know, it just sounded like it's a,
If the individual homeowner entrusts that person with their votes.
That's-
I think they have the right to do that without giving a portal on someone who wants to go out and select. 5% is nothing, that's pretty good, that's nothing. I mean, I've held proxies for more than that, just in my forms, that people are outstanding. They want to have their voices heard, and, you know, they trust me or another neighbor, you know, to do the right thing, represent their interests. I think we should have that ability to do that. And if you had a higher percentage, you know, that might be more, maybe 25%, something like that, but 4% is nothing. It's the deal. I think that's far too big of a burden and a hurdle to impose on homeowners.
there was people that had 7 proxies or 6 or 7 proxies plus their vote at the one big meeting, and they have a right according to all of our bylaws and everything. So that is like 10% of 87. So that's more, you know. I don't,
Penny,
I agree with
Consider the implications before we go off and start adopting a policy that really limits the limits of what we can, even though he's not there.
Yes.
Yeah, I think I understand both sides of the point. And for me, it would fall back on what we would send customers practice in the neighborhood. Because I don't know. I would be really alarmed if I found out someone's going out and knocking the door, solicitors for their block. And that's not how it works in my neighborhood. We want to participate in the process and do our own due diligence. What we do is if you're going to be out of town and can't go to a meeting, you ask someone you trust
Yeah,
to be able to speak for you. And I have never experienced the opinion that there's someone doesn't ask me to how you feel about an issue. You go in there, it's not like you're someone, if you found out that the custom here, some people are going out soliciting, trying to get people to give them their vote. I would be really concerned about that. And so if the practice here that I know is throughout the neighborhood, then I think it might be wise to wait on this and see what the practice is now, if people start coming in. And you can always revisit the issue of extending this new policy because as you mentioned, doesn't prevent you to go a little bit more long, as long as it doesn't contradict the legislation. You could go on and do that, so you could come back and visit this limitation on processes until you see how in practice it's going to happen. That's how
I agree with Clark. I think this is a sure version of problem, and the problem doesn't exist at this time. So let's not.
I agree.
Okay, so
We're
we're repeating ourselves now. So Andy, given this discussion, do you still wish to proceed with the amendment?
What I'd like to do is, if we could table this for a broader discussion at the homeowners meeting, when we have more people to have more input on the subject, I think that that's reasonable. And given the fact that this is likely to be a topic that goes through the next session, which won't take effect until next August, we have time. So there's no rush on this.
So I'm gonna step aside as the president and speak as a board member. We don't have in our documents sorry, Andy, I can't remember what you said. But there is something in here that we don't have in our document. So
essentially.
my preference as a board member is to remove the amendment or vote it down and proceed with the policy, revisit the whole issue of limiting proxies. That's now I'm back in as president.
So let me, is it, the homeowners meeting agenda, is it separate topic? Do you perceive any reason we cannot table something to that meeting? Is that not allowed?
Because the policies are set by the board.
Right, but
And so this policy without the amendment is very innocuous
agreed.
and could easily be put into place.
And based upon that, I think we've raised the subject. We're aware of it. And I can withdraw the amendment. We don't need a separate vote on that. I have a second point about the way that we're writing this policy. It's covering things that are in bylaws. And I have reviewed several other HOAs' approach to compliance with the new legislation that is passed. And quite a few of them, when they write a new policy, will cite what is being changed, the section that's being changed. And there's only really two sections. It's all in Article 5, Section 3, and then there's letters. C and F are the main two sections. It would seem to make sense that the policy has some marker we've gotten into the weeds on this, so we've looked things up. But a homeowner is going to look and maybe read the bylaws or maybe read this policy, but they don't build the bridge and the connection between the two. If we're gonna create a whole new policy covering the same topic, we should at least have a reference there so that it's less confusing. And it would, and the manner that I've seen in other approaches this year is simply to say, so, in this case, you are, the only real change is a proxy is void if it's not dated, which could be an additional letter in the, the bylaws, or you could acknowledge with these other sentences that you're addressing Article 5, Section 3C with the 11 months section, and F in 3F, we already require that if you're going to revoke your proxy, you do it in writing. Our documents already do that. So you've got a sentence here about purports to be revocable without notice. We don't allow that already. We don't really need to say that. So that.
So again, that came straight out of the act.
Mhm.
So to address your comments.
Mhm.
I usually, again, board member. I usually prefer pointing to the other documents. Our documents are so screwed up. And we've been trying to get the bylaws redone. That's gone down the hill. If things ever get changed, then that would require going through every single policy and revising each policy to make sure that it references the correct section of what it was originally referencing. I don't know about the rest of you. I don't have time or the inclination to do that. President. Yes.
My only counter to that is we don't have to tackle the mountain. This is the molehill in front of us. We can start doing it right with the policies we're passing today. Just because there's other things, agreed, that are difficult references, doesn't mean that we can't start doing it right just because there's still work to be done elsewhere. It's simple. It's a one line item to note what we're changing and where it's coming from. So minor change.
Further comments? Yes.
The document revision situation has been on the table for years. So to say we don't want to cross-reference because it might be hard 5 years down the road seems really to be an invalid argument. I think it's very difficult to read and your average homeowner doesn't know how all the documents fit together. So having the cross-references will allow them to much more easily do the right thing. I found it confusing. I found the references to see our other documents or as referenced in other documents frustrating, and I know our documents better than most of our neighbors.
Mhm.
So I would agree to add that you should consider adding cross.
Further comments?
I'm of the opinion that it's so screwed up, there's no way to fix it without a complete revision.
All right, so.
Well, we could do it. This is what-
Okay, stop, hold it, stop. We're, I allowed, comment. I think we're done with the homeowner comments. I don't hear any other board comments. All right, all in favor of approving this policy? Opposed? It is
Would-
approved.
We didn't vote on whether or not we wanted to have add the reference.
Because nobody offered an amendment. All right, our next policy is the prohibition, regulating public right of way policy.
I move to approve the regulating public right of way policy.
All right. Homeowner comments.
You don't have any leeway with regard to that, from what I understand.
No, we have absolutely zero leeway.
What's that?
All right, board comments, Andy?
First of all, on the printed copy that was mailed out to everybody, the numerology begins with number 6, introduction. I think this is a formatting issue with Word. I think that the digital copy that I received, that each policy begins with the number 1. And so I think that might have just been something that happened in printing. But
So are
we-
you,
6 should be changed to 1, 7 should be changed to 2, 8 should be changed to 3, 9 should be changed to 4. It looks like all 4 policies were added to the same Word document, and because of how numbers go in Word, as we'll see in the next policies, it keeps going. The next policy begins at 10. The next
So-
policy, so
the amendment, there is a motion to correct the numbering of the policies.
Yes.
as Stated,
I have a couple others.
one moment.
Okay.
There's also, I don't know if you noticed under certification, proxy policy. I would
Yes,
move to remove proxy and insert deregulating public right of way.
right.
Into there.
I have a question.
Okay.
So currently number 8, because we haven't approved this, public right of way policy. The sentence, notwithstanding any provision to the contrary in the HOA documents, seems to indicate that you're saying, well, these prohibitions, unless our documents say so, that the documents are overriding.
Notwithstanding, if I am correct in the legal sense of the term, means nothing in the HOA documents overrides this. There's another phrase that is often used, which means exactly what you just said. But notwithstanding means it doesn't matter. This supersedes.
Well, there are provisions to the contrary in the HOA documents.
That's
So that,
point. Yeah, that's the point I'm making.
I think this language might not be well understood by some homeowners. I think this is a little confusing. And
Again, it came straight out of the.
can you tell me where it came, what specifically? I didn't bring a copy of this
I
particular.
don't have a copy of this one.
I find that confusing. I think there could be better wording, and I don't think that the statute requires you to change your policy to this. I don't think there's any requirement by the statute that you use this wording. Final point, in terms of cross references, Article 10, use restrictions, Section 22, line 3, has the words on any street. And you could simply add that to make it clear that part of Article X use restrictions no longer applies to on any street. And in Article 16, Section 4, there's actually a requirement that we are released by the Larimer County Board of Commissioners before we make any changes. Have we made contact with the Board of Commissioners? This is Article 16, Section 4,
Of what?
CCRs.
So
I think it's a crossing a T, dotting an I, but it's in there, and I think we probably need to actually do that.
given, again, this supersedes. We have to do this. I mean, this is the policy. We have no choice. And Larimer County cannot tell us not to do it.
Okay, but section 4 reads, in no event shall any provisions of this declaration relating to the responsibility to maintain the public roads and streets or common elements within the common interest community be amended or expire unless specifically released by the Board of County Commissioners of Larimer County, Colorado.
And I would argue that it says to maintain, and this is about maintenance of the street. This is about public right of way.
Notwithstanding, it just means that it's fine.
Yep.
This,
You want to make such a motion, but in spite instead of notwithstanding.
I think it's the word statute, not the same for clarification. Basically, what they're saying, despite anything you guys have, this will. Further than me.
Which is what, notwithstanding.
Okay, so that's Paul.
Yeah,
Paul, go ahead and we are going to enhance you with the microphone here. Go ahead, Paul.
yeah, I just had one comment and I may be reading this incorrectly and please let me know if I am. But under number 8, public right-of-way policy, the way I read this, notwithstanding any provision to the contrary, which of course we have in our documents, which is the next few words, HOA documents, the HOA shall not. So the way I read this is that we already have in our HOA documents certain prohibitions that are laid out that prohibit certain items, such as, for instance, RVs being on the street, or that's just an example. The way I read it is, notwithstanding any provision to the contrary, well, we have that to the contrary. And so what we have already should be in effect and stay in effect. And shouldn't be if in any way change as a result of whatever law that has been written that supersedes this.
So this.
Does that make sense?
Well, it seems like you're interpreting notwithstanding, not in the way that we're thinking of it.
Well, I think I'm interpreting the way that I've always had after working on Capitol Hill for 45 years for Congress. That's the way they interpreted it.
so let me see if I understood what you said correctly. Okay, Paul.
I'm sorry,
Can you hear me?
I can,
Let me see if I understood what you said correctly.
certainly.
You're saying that our HOA documents supersede this policy.
According to this, the way this is stated, absolutely.
And
They're very-
again, the notwithstanding, while I understand Capitol Hill because my husband is there all the time, notwithstanding in this sense means nothing in our current HOA documents trump this policy.
That's not the way I read it.
And that's why the suggestion was to remove notwithstanding and to include despite.
Or in spite.
Was it in spite?
Saying means, despite anything you all
Just-
already have on the books, this law is on its job. That's what it means.
Well, this notwithstanding, who wrote this line? Notwithstanding any
Came out
provision.
of the it came out of the act.
I think they were very specific, and what they meant was that in layman's terms, if we have something in our HOA document that supersedes this, then that is what we should follow.
No.
No,
Backwards, Paul.
you've got it backwards.
What?
I think you've got it backwards. Your understanding is contrary to the way most people are thinking about the sentence.
That can't be true.
So
So,
I will actually make a motion to remove notwithstanding and insert despite, as that is the intention.
I have a,
Despite any provision to the contrary.
why can't,
Yeah, go ahead.
I'm sorry, Paul. So why couldn't it just simply begin after the comma, the HOA shall not? I'm looking at the wording on the bill. And this is the final version from the state website. And there's no, notwithstanding anything about the documents at all within this bill.
Because, well, as has been pointed out, you want to make sure that people understand this supersedes what's in.
Well, I see what you're doing. So notwithstanding any provision in the declaration bylaw, okay, I see what you're doing here.
I don't read it that way. I read it the opposite way. I think if you already have something in your HOA document, that would supersede whatever is stated here,
That's so I can help
after HOA shall not.
Sure.
who
But
wants.
that's the language of the bill. So that sentence is right after number 1. Hold on.
Please put
I-
the people.
I will, just a second. I have to coordinate my mouse movement here.
Thank
Okay, there we go. We could do share screen if we need to show anything, and then everybody at home can also see it as well.
Are there any further comments?
Well, who wrote not?
That's,
Came out of the act.
so
Right.
Paul,
Okay. I
It-
think what they meant is, in my estimation anyway, a layman's term, is that if an HOA already has something in place, then in other words, if we have what we already have in our HOA documents, then these, the following 1 or 2 don't apply.
Think you
Why
have,
else would they say
Are there
notwithstanding?
any further comments? And
so I'd like to just, my proposed amendment is, in spite of it being in the law, this is an example of the confusion that can be caused. Why don't we just strike everything before the comma and just say the HOA shall not?
because.
But that's not the intent, that's not the intent of what they wanted, of
Amendment,
what they stated.
I've already offered up the amendment to replace notwithstanding with despite.
Well, so how
Vote
do we read this?
Or-
If despite supersedes notwithstanding, what does that mean?
We also have,
Any further comments?
we also have an amendment to change the numbers that we didn't
Yes.
vote on. So
Yes.
we've got 2 amendments already floating.
you would.
So what's the
Any-
bottom line?
Any further comments? Yes,
Yeah. Even changing the site, if they let it still have working orders and the building and the house. No way of keeping that. If I do that, you say, if you want to stay true to what the legislation says, you get it. You get it straight. Anybody can explain how that interpret this. It means now we're saying that legal station supersedes anything else that we really have.
Gloria, did you have a comment?
Notwithstanding is used within violence.
Sure.
And it is also exactly that. If you've got something in your documents, this supersedes it.
All right, we will vote on the amendment to replace notwithstanding with despite. In favor? Opposed? Right, so that fails. The one before that was to replace proxy under certification with regulating public right of way. All in favor? Okay. And then the third correction was to fix the numberings 1, 2, 3, and 4. In favor?
I had an amendment also to put the reference for Article 10, Section 22, just saying we're striking on any street, which is a CCR. We're simply striking that language so that there's an understanding, so that somebody doesn't go back and read this and then see notwithstanding and have this time-consuming
And
debate back
where,
and forth.
so you can, so to add language, you need to say where it goes in here.
So that would be under what we've just now numbered, Section 3, Public Right-of-Way Policy. And add, so you're using Roman numerals 1, 2, so add Roman numeral 3. CCR Article XV1, which is 16, Section 4. Excuse me, Article, excuse me, wrong reference. Article 10, use restrictions, Section 22.
So is that Article X?
Article X 10, use restrictions, Section 22. It's on the third line, if that's important. Just simply strike the words on any street.
So we can't change the CCNRs.
Correct. This has the effect of striking those 3 words. And I think that would give some clarity for anybody who has confusion.
I'm not trying to argue clarity. I'm just trying to get the wording.
Mhm.
Okay, so you're saying number 3 of this Article 10 of the CCR, Section 22.
Yes.
If
If not strike, invalidates. Anybody got a better word? Supersedes. Those 3 words. So when somebody goes to read that independently in the CCRs,
what
there's
were-
nothing, since we're not changing the CCRs, they're never gonna know to go look at this
What
policy
were the 3 words again, please?
on any street. That particular section describes a bunch of things. This would clarify that.
All right. Comments? All right, all in favor of adding under public right-of-way policy, Roman numeral 3. How would you start that, Andy?
This policy supersedes Article X, use restrictions, Section 22.
So
The
this,
words on any street. Wasn't eloquent to say out loud, but that's the effect.
okay, so this policy supersedes CCNR Article X, Section 22 on any street. All in favor? Opposed? It is passed. Okay. We will now vote on the, I will call it the amended policy. In favor of the regulating public right-of-way policy as amended. In favor? Opposed, so. All right. I would like to ask a 5-minute bio break. if we could. I will be right back. It's 7:05.
So we're still on time.
Yeah, we got it. 7:05, recess. 7:10, we will start up again.
Do we still have everybody?
We getting somebody too?
Well, I can talk to Paul and see if I can convince him opposite
Well,
of what he's.
Question for you. One tree out in front.
Yeah, okay,
I know,
what do you propose?
Get it fixed. We replaced.
Paul, are you talking to either of us here?
Okay.
Yeah, I am. It's so nebulous
The
and
second
contradictory. This,
here, but not for the second.
Oh, okay, I didn't know.
So Paul, I actually, there are sections of, Kiowa that actually do precisely what you're talking about. They allow, the HOA documents to vary from strict, following or interpretation of the state law. There's probably over 10, maybe over 15 sections of Kiowa that use notwithstanding or similar phrases that allow essentially variances in HOA governing documents. So I actually agree with you on your general point. That said, if you're at a computer, just Google House Bill HB 22-1139 and just go to the Colorado legislative site. I'll see if I can put this in chat while we're talking.
well, I'm on the Zoom and.
That's
on
okay.
iPad
Do you have the chat open? Hold on.
Chat.
Oh, I don't even see the chat. Hold on a second.
Oh,
Did that do it?
let me read this a sec.
Anybody notice that the Dow went down almost 1,300 points?
Well, hold on, let me just back up a bit.
Average
So,
In the deck.
last year has gone down $3,000 in net
In
worth
association shall not prohibit.
after today. But it's just gonna add to it.
so what I'm going to scroll you to, Paul, is on
Yeah.
the next page.
Sure.
Okay, this is what was actually passed. All this capitalization. So it added sections.
It says here, additionally, the association shall not require that a public right of way be used in a certain manner.
Right.
So that seems to contradict what,
It's confusing. And that's it,
No, not
even with all of your
confusing to me.
experience, it's confusing, right?
no, well, that's, that's legislation.
Right.
It's like reading the legal, it's legalese, but scroll back where you were, no, up, back, down, see that?
Right there.
It says here, additionally, the association shall not require that a public right of way be used in a certain manner, which is precisely my point.
Right.
What's written in our documents
queued up. That's all.
What's written in documents is what,
We are back in,
Okay,
in.
Paul, I'm gonna pull off the share here.
yeah, no, that,
Everything's
Our
back,
next
good.
policy.
that sort of makes our point, my point.
Okay,
is
Paul,
the-
we're
That-
reconvening.
That line supersedes
Our next,
what we were talking,
Paul, can we table that? We're
Yeah,
proceeding
yeah.
here again.
sorry.
our next policy is reasonable access to common elements areas.
Okay, I move to approve reasonable access to common elements areas policy.
So I would offer a correction of numbering to number sequentially, remove 10, make it 1, 11, 2, 12, 3. I think it flips to the other side.
Yep.
13 becomes 4.
And in the certification, as well as the title of what will newly become number 3, that also says proxy policy in both places. It needs to be the actual name of the policy. So I have a question. Oh, you got to do homeowner comments first. Sorry.
All right, homeowner comment. Okay,
I have a question. This policy, or excuse me, this particular act, I know why it came up. I participated in the discussions. And what was happening was, particularly during COVID, there were shutdowns of certain amenities in places that are completely unlike ours. Places with restaurants, pools, things like that. And one of the frequent complaints that was heard was kind of the weaponizing of that. In some cases, a board would say, you can't use the pool, you can't use the restaurant, and
So,
they would make
Andy,
up a reason.
What, excuse me for interrupting.
So my
what
question
is
is,
the-
what
yeah.
common elements do we have that this would apply to? What could,
Well, the common elements that we have are the open spaces. So it doesn't, the policy does not differentiate, the act, excuse me, does not differentiate what the common elements are. It doesn't define them. It just says the common elements. Our common elements are the open spaces. So while you may think that this is ridiculous and
no, I'm not,
it's just,
so I'm
we
just trying
have
to,
no
trying to
common-
imagine when this would apply.
well, no, excuse me. When it would apply is not really the point right now. The point is reasonable access to the open space.
This is easy. For instance, I think if you all contracted to spray a herbicide out there, we restricted access to the health and safety of our members. We tell them not to go on the property for 12 hours. I think that
Right, so are there any further comments from the board on the policy?
Well, that's the question that I'm raising here is, what's the necessity for this policy, since we don't really have, you think, I mean, there are times, have we ever done this? Have we ever
So,
restricted access?
okay, Andy, you're the one that made the big deal back in June and July.
Okay.
That we needed to get our policies in order to comply with the recent legislation. This policy
Okay.
complies with the recent legislation. It does not differentiate what the common elements are. That's all this policy does. So I will not entertain what ifs or when woulds. I will entertain comments on the policy itself.
Okay. So one of the things that this policy addresses is restricting access. And this, you have the grass area that's in the center, Does this include the backlots?
Yes, if it's a common element, it
Okay.
includes everything.
Okay, so, okay, then I think that we are, entering a new era where, this may come up in the future. And I'm wondering, I think this is compliant with the state law, but it's opening up a discussion about, how those things are restricted. And seeing as we're in a neighborhood where adjacent neighborhoods use those spaces, particularly the outside, I don't see how you're ever going to have a restriction in those areas.
So that is a discussion that we will have should we ever need to. But that is not a comment on the policy. Are there any comments on the policy? I'm looking up here because I forgot to look before. All right, so our first amendment or correction was to, under certification, correct proxy to, homeowners and their guests reasonable access to common elements areas. All in favor? Okay. The next one is under Old 12. Remove proxy and insert homeowners and their guests reasonable access to common elements areas. All in favor? The last one is to correct the numbering. All in favor? So now we will vote on the policy. All in favor of accepting the policy? All right, this brings us to our fourth policy. This is the homeowners association procedures to notify homeowners of alleged violations and procedures and legal actions the HOA may take against homeowners. This is comes from House Bill 22-1137.
I move to approve procedures to notify homeowners of alleged violations and procedures and legal actions the HOA may take against homeowners policy.
Okay, I would offer to amend the numbering.
Could we expand on that topic just a little bit? The numbering that begins 14, 15, 16, and 17. Numbers they go up to 19, 20. That's the word issue. I think it would be a good idea for clarity. I see what you've done, and I know that this is organized, how the bill is organized, because the bill has 6 sections. And so you have section 1 through 6. It might be a reasonable idea to alternate 2 letters instead of starting over with new, because you're going to have a section 1, and then under section 1, then you're going to have a number 1, 2, 3. As somebody who's done a lot of work going through documents, the references on this and discussions about it are going to get difficult if we do it this exact way. I'm only suggesting having the paragraphs under these sections begin with letters. I think it's just going to be easier for everybody to understand.
Right. Are there homeowner comments?
Not with regard to the number.
No, I mean in general. I'm sorry.
It's the most
Apologize if I wasn't.
convoluted, totally different piece of legislation I ever read. But, other than that, no.
Board comments. Here. Don't see any.
Okay, so I have a few. I'll just go through them one by one. So under your section. So on the second page, what is numbered currently 3, you have 3.2. Provide homeowners at least 7-day period to cure a violation of any HOA governing document before imposing a fine. I understand that you've said that this comes out directly out of the act. I do have a printed copy here. Could you, I think that there are 2 problems with the 2 types of scenarios that are envisioned by this bill. So this bill has regular violations, and you cannot impose a fine until after 30 days. Then you have anything that would be an effect on health and safety, just to generalize. And there you have to wait 72 hours before you can impose a fine. And I can talk a little bit more deeply on the 72-hour part, because that's problematic for another reason. If
Well,
there's-
let's not. Let's just stick
But,
with what
but
you're
the seven,
talking
but there
about.
is no actual provision saying that you're giving homeowners a 7-day period. That does not appear in the act. Could you please point to the reference where that's coming from? I don't think that that's correct and should just simply be stricken.
Give me a moment. This is section 1. I would offer, because I don't want to spend a lot of time going through this act, as been stated, it is a tough one to try and read. I would offer that if you believe that is incorrect, you propose to fix it.
Then my amendment is to strike 3.2. You go into good detail about the 72-hour period and the 30-day period in the following
So let's
paragraphs.
just stop. You are proposing to strike
3.2.
3.2,
It doesn't serve us.
right? Any further board comments?
Do we have an actual working copy of the statute? Yeah, I hate to strike something that's the law.
Well,
It's not in the law.
It's question, so I would personally not strike it unless at this point, I would offer to strike it if it could not be verified. Because that's the question, is verification of this 7-day.
Well, what you want to do is table this discussion on this until it's determined what is the law. Ratify this. in this time.
It's not anywhere in here. And we can do this, if reading through it on paper is too hard,
Okay,
have the internet,
stop,
we could do a
stop.
search
We're
for
not doing that, we're not doing.
it's not in the law. It literally contradicts, look at 3.4.1.
You've made your point, Andy.
Okay.
If you may, just move on to whatever your next point is.
Okay. So the 72-hour period, one of the things that happened during the legislative process, that was actually an industry amendment that was added. When,
So Andy, what's your point? Don't give us the history. of
I'm
how
sorry,
this got in
please,
here. Just tell us
because
what
this is
you're
important
getting
for
to.
clarity for anybody who hasn't heard it. I'm sorry, please don't rush me.
Andy, I'm going to say one more time that the comments are related to what is your issue with the 72 hours without giving us a 20.
I'm sorry, I'm just gonna have to speak the way that I speak, and I'm sorry if that annoys you or irritates you. There's a very good point, and we're spending more time on it. Just let me say it. So the standard and what's going to happen in the next legislative
So
session.
Andy, we don't care what happens in the next legislative session because that is all hypothetical.
Please define health
What-
and safety for me.
What is your,
Please define when a 72-hour period applies. What's the definition of health and safety? And what
Health
I'm
and-
saying, it should be irreparable harm. So that the 72-hour period should only apply when there's irreparable harm.
but
And in
that is,
fact,
that is not what the document says. The act says health and safety.
if you would have participated in the town hall on the 24th
I
with
was
Representative
not
Ricks, who was
in-
responsible, can I speak without interruption, please?
If you will stop attacking me, I'd be happy to let you speak.
So that's your terms. Great. Please don't interrupt me any further. So the problem with the 72-hour period is that if there is an actual situation of irreparable harm, it's too long. The board needs to take action immediately. And so that has been a known problem. It needs to be addressed. Everybody knows that change is coming. And with that foresight, knowing that that's the change that's going to be introduced because Representative Rick said so out loud at the 824 town hall, it would be a great idea for us to define what is health and safety, because one of the problems that we anticipated was that some people would say, well, dandelions could give somebody else an allergy. And we're just going to make that now a 72-hour time to cure because it's health and safety. And that we will bend the 30-day time to cure to fit anything that we can imagine. So it would be a great idea to include in section 3.3 the standard of irreparable harm, because that's where we're going, and it's going to probably be that way next year.
So
Hmm.
I hear what you're saying. All I can say is what the act says. If there is, if there are things that need to be added that require discussion, that would be longer than the 45 minutes we have left, perhaps tabling this is appropriate.
That was the entire discussion. Add irreparable harm as the standard
But
to
again,
determine.
you've got to define irreparable harm.
Irreparable harm is the biggest standard, and I don't think you're in a position.
I am very uncomfortable with that.
Based on this discussion.
Okay, so just to be clear on that, okay, this is the idea that is not my personal proposal. This is, I'm reporting to you what the discussion's going on with the legislators and industry people, including CLAC, CAI, and people from community area management industry.
All right, so, okay, so let's hold on.
Irreparable harm is the definition.
Correct.
Go down that road. Down the definition.
I agree with that.
So,
Health and safety is defined as what in the act or in this document?
I think that's open to a reasonable man standard as to what that means. And I think the board is qualified to make a decision for a certain situation.
If we make a decision that's incorrect, there's a $25,000 penalty.
What's incorrect?
all right.
So if we deem
okay.
something as health and safety
Yeah,
and we're wrong, then the person that's applied to and you didn't give enough time to cure, they could actually go to court and collect on that up to $25,000 penalty. That's what's at stake.
All right, hold on.
I have a question.
Yes, fine.
So the legislature has told us that we must adopt these policies.
Mhm.
So what is the penalty for not adopting the policies?
The statute doesn't tell you you have to change your policy. The statute doesn't say that. That's just an effect. If you have anything that is contradictory, it's the action of following a bad policy that could lead to a penalty. That's what's,
And since all
That's
of
what's
our
new in this.
documents right now, or not all of them, but a good portion of our documents right now are in contradiction of this policy. We as a board we are bound by law to follow the law, which supersedes our policies. So should something arise, and I'm just thinking out loud, should something arise that this policy would be used for, if we don't have this policy, we reference the act. Yes,
so Kiowa has requirements for policies. There's 9 of them. One of them is we're required to have a policy for covenant enforcement. If we pass this policy, while we simultaneously still have a covenant enforcement policy, which does talk about enforcement and time periods, they're in contradiction.
no, they're not, because this policy supersedes that.
But you can't, if you supersede it, then you don't have a covenant enforcement policy, then you are actually in violation of Kiowa. If you don't have this specific policy named this way, you're not in violation of Kiowa. What many other HOAs are doing is just simply revising their covenant enforcement policy. My
Yes.
argument is this should be a subset of the covenant enforcement policy.
This thing is so complicated and so convoluted. And our covenant enforcement policy, I would personally prefer to have a committee of 2, 3, 4 members that would be willing to take on the job of melding this policy with the covenant enforcement. Because that has to go, if you change if you change. Back down. No, I was thinking of something else, sorry.
I mean, the bottom line is, if you have a violation, given the new law, you're gonna consult an attorney. This is the attorney to read that, because there's not a homeowners association in the state that's gonna try to do this on their own. It's hard to, it's a disaster. It's full of traps and.
So how,
Can I make a comment on the idea that you just proposed?
yes,
I think it's a good idea. I think that what I've been saying is this should be a discussion that leads to some work, and I agree, we have people that have been willing to work on these policies. And I agree, there needs to be not a superseding policy, because I don't think that that's allowed. I think we should look at making something that everybody understands clearly. We already have a confusing policy. We're going to add another one, even if the law is terrible. And that opinion has been promoted by industry people that are making a lot of money from this.
so.
So my proposal is we table a vote on this. We have a discussion this evening about specific things, but that we literally form a committee or a work group to do that work and have a clear and effective covenant enforcement policy.
So let's step by step. So your first motion was to table the vote on this policy.
Mhm.
Correct?
Yes, I think we could probably, 2 weeks, it would be a ambitious scheduling, but within 4 weeks, I think those that participate can catch up. There are plenty of people out there willing to assist as experts.
So back off 1 second, because the question is tabling them. The motion is to table the vote on this policy. Discussion on that motion, because that motion supersedes all other motions.
Gloria has something to say.
What would be the penalty if we don't have something in place and we do it wrong? 25,000,
Up to,
up to 25,000.
so then, so if we-
Have something in place temporarily,
Mhm.
which is the law.
Mhm.
Then you can still work on it. You say that some parts of this is going to be amended in the next legislative session.
Mhm.
You can't anticipate that, but if it is, then you're gonna have to change it anyway.
which is why it would be a good idea to only change policy and not CCRs or bylaws at this time, which was expert advice from David Steiger,
So
given the expense. of
further
doing it.
comments on the motion to table the vote on this policy.
So as I understand it, there is the possibility of a fine of up to 25,000 if we don't adopt this policy.
I think
No.
you're wrong. I think there's a fine if we don't follow the law.
Right.
Whether we have a policy in place is irrelevant. If we decide to fine a homeowner to proceed legally against them, we have to follow what's in that statute. Whether we have a policy or not, that is our policy.
Okay, so there's no immediate risk by tabling.
Yeah.
Oh, I just wanted to clarify that.
Yeah.
And
You're-
likely we'd have to consult a lawyer anyway and say, hey, follow the law and do something against this homeowner. Yeah, that's what it's gonna come down to.
And if I can help advance our understanding of it. So the main elements here are creating cure periods that are defined by state law. We kind of do this already. We've changed, so there were times in the past where we were telling people comply, and 3 or 4 days later, we'll apply a fine. We can't do that anymore.
So the motion on the floor is to table the vote on this policy. Any further discussion from the board on that motion?
Yes, so if we're tabling it, are you ending the discussion this evening?
Yes,
Because we're all here.
so the policy is we're not finished with because you had another part. The policy is to table the vote on this. The motion is, sorry, to table the vote on this policy. In favor. Okay, the vote is tabled. Let me make sure that I get this captured. All right. The next part of your what you were saying, as I understood it, was for the board to create a committee of individuals who are willing to serve to take the enforcement policy and this act and meld them together. Is that correct?
I think we talked about, some work has gone into creating this policy. I think the discussion point was melding the two policies together. But that said,
Well, then
I would say it differently. Let me take a different stab at it. In some HOAs, and it doesn't have to be in ours, in some HOAs, they found of the 9 required policies, some of them found changes necessary in 4 or 5 of those required policies. Things like the interest rate, they're minor changes. So melding it with our governing documents would be a more accurate statement because it may
Except
affect
if you
more than
try
the
to
enforcement.
meld them with CCRs, that requires a member's vote and 2/3.
You,
if
you just
you-
had an instance before where you said it has the effect of striking that language. We could do the exact same thing, because that was
It has
actually-
the effect of striking that language, but we
Right.
are not amending the CCNR.
That's correct. So the
So if
good
you
example
are
is the
going to
interest rate.
Propose to amend the CCRs, those have to go to a members meeting.
It's not the point. The point is knowing that there's a section in the CCRs that talks about 18% interest and it really needs to be 8%.
That is a change in the CCRs that has to go before the membership.
The policy that you proposed here talks about 18, or it talks about 8% because that is following the law. You
That
can't
is
charge more than
correct.
8% interest.
If you want to actually change the words in the CCNRs,
Not talking about that.
then that is a member meeting decision with 2/3.
But we've already discussed referencing those sections so that there's not confusion since we're not changing the CCRs.
So back to what I said. The board create a committee
Yes.
of willing homeowners to take this policy and our enforcement policy and come up with a recommendation for policies for the board to consider.
I'm somewhat confused. I don't think any board or committee can change the law. That is the law on how you're gonna deal with homeowners.
Right.
Okay? So you're not gonna meld them. You're not gonna massage the language. That's the law.
Well, I don't think that, Walker, that that we're trying to change the law's language. It's going into our enforcement policy and get it in compliance with the language.
Can I address a comment with that comment with an example?
No, we don't need an example.
Supersede anything that we have.
So,
Can I make it?
So-
I'm-
are there any further comments on forming the committee?
Yes, I have a comment
Okay, on forming the
So-
committee.
on forming the committee. So the committee's purpose would not be to try to override the law or avoid the law. However, one of the problems that's occurring out there is interpretations of this act.
So stop, we're not interpreting anything. We will,
If I could-
we have to come up with a charter for the committee. If this passes, we have to have a charter.
Can I
for the
please
com-
finish my sentence?
For
It's, ju-
the
it's
committee,
really not that difficult. Please let me finish my sentence.
we have to have a charter for the committee, which will then tell the.
Please let me
committee what
finish my
it is
sentence.
Supposed to do.
May I please finish my sentence?
Any further comments on?
Yes, I'd like to
forming
finish my sentence.
The committee.
So
So, okay, let's hold it down.
okay, so there's a provision in there about posting notices on doors.
This is not a comment on the forming.
It
the
is a
committee.
comment on the forming of a committee.
How?
Because the committee has to consider whether or not some of the people in the industry say the first notice has to be posted on the door. And I'm prepared to show you a video from the 24th of the town hall talking about how that is absolutely incorrect.
So Andy,
So that
this-
needs
what
to be
does this
part
have
of the
to do
charter of a
with the
committee.
committee?
Because the committee needs to understand that there are interpretations that need to be weighed. It is not straightforward. The law does not just tell you strictly what to do. Period. End of story. There are interpretations that are part of what this committee needs to consider, including the fact that only when there's a delinquency is there a posting on the door when you're on the
All
cusp
right,
of taking
so-
legal action.
So we will now vote on forming a committee of willing homeowners to I'm trying to make sure I
Mel,
to look at the policies and our enforcement policy and come back with recommended policies for the board's consideration. In favor? Opposed? I personally don't think we are going to get. I worry about getting people to work on this, so I am going to vote no. So that does not pass.
So we're back to voting on the policy tonight.
No, we're not. That was tabled.
Those table.
So we're tabled.
All right, so the next board meeting, or the next agenda item is determine the next meeting date and time to prepare for the members' meeting. How would the board like to proceed with that? Members, we have to figure out the members' meeting, where it's gonna be, what the agenda is gonna be, all that good stuff.
When is it traditional to hold the members meeting?
Wasn't it in November?
It was always in early November.
Yeah, usually November, something.
It was usually, well, let's consider when Colorado elections are. We should probably not
Yeah,
Right.
do it on the same date.
I think they pushed it to, early December.
yeah, I think the.
Last time it was early December.
Holiday.
All right, so, given we also have to determine where it's gonna be, we've got a lot to discuss. So how would the board like to proceed on, our next meeting date and time?
Do we know the date of the Colorado elections?
Well, we need to, as a board, get together, and so the elections are more or less irrelevant, because we as a board need to get together and come up and determine anything, because if there's mailings and notice times, there's all that good stuff, so.
Tuesday, November 8th is the Colorado elections.
So after that would be preferable, but not close to Thanksgiving.
So
week
hold
after-
on, time out.
Okay.
We are not trying to decide when to have the members meeting. We are trying to decide when to have the next board meeting to discuss
Oh, I
the
get it.
members meeting. Because we'll have to talk budget. We've got to talk all that good stuff. I have to tell you, I don't have my phone with me, and so I don't have my calendar. Would the board prefer to come up with a date and time by email?
I
Or
think,
set a date and time, and if it conflicts with stuff, we can reset it.
so you want to set a board meeting solely for the agenda of setting the homeowners meeting, or don't we need to work on this 1137 stuff?
The next recording, this is to deal with the members meeting.
Okay.
That has been tabled.
Okay, so I believe that we originally had a meeting on Tuesday, the 11th of October on the original schedule.
Thank you, board members.
Thank you for coming. You're the last holdouts.
So Tuesday, the 11th,
I have no information as to why.
I don't either. Can we suggest Tuesday, the 11th?
Sure.
And let us check calendars?
Sure.
Okay.
Tuesday or Wednesday, I think, is the better 2 days of the week.
All right.
Lori King.
Then we are at the end of our agenda, so we stand adjourned. What do we need to do do they just come in and?
You just
clean
have
up,
to
or do we
say
have
goodbye
do
to everybody.
something?
Goodbye. The equipment, I think we're just gonna leave in place, but we're gonna say goodbye to everybody here. Thank you, everybody, for
Thank you for
participating online.
participating.